be seated. Ladies and gentlemen, for some preparatory matters, obviously we have a full courtroom. There was no request for one of our larger courtrooms. And that aside, we do have COVID protocols that are in place, which does try to limit the number of folks here. Obviously, there are folks standing and other folks that may be interested in watching these proceedings. These proceedings are being live streamed through audio feed through Kelloland and through the Argus, as I understand it, maybe other media outlets. And so there is that opportunity to log on to those websites and to then listen. But I can't have people standing in here as this goes on. So I'm going to ask you, those of you that don't have a seat, please, you'll have to excuse yourself. And but you can access this proceeding through that media outlet or outlets. Further, as I go forward here, ladies and gentlemen, obviously this case has drawn a lot of attention in the public. There may be a lot of emotions that may play out throughout the proceeding. I cannot have and or tolerate any outburst. If you feel that you're going to become emotional, and that's okay, please leave the courtroom. And unless you can control those emotions, then please do not re-enter the courtroom. That's the way it is, because we need to conduct this business that has to be taken care of here. And again, I understand and recognize that there is a lot of emotions that may play out and or public interest that occurs. So those are some of the ground rules, so to speak, as we begin this case. And this case is State of South Dakota versus Theresa Rose Bentis. This case number 19-1657, that the court did receive an Alfred plea from Ms. Bentis previously. A pre-sentence investigation was conducted. That information has been gathered and put in a report that's been shared with the state as well as with the defense and the court. That information is confidential. It's not available to the public by state law, but the parties do have the opportunity to review it for purposes of either commenting on it or adding additional perspective to it. Mr. Sample, have you had the opportunity to review that pre-sentence investigation report?
I have.
Any corrections or additions you wish to make?
No, Your Honor.
Okay. Is there any reason for delay in sentencing from the state's perspective?
No, Your Honor.
Mr. Sergeant, Ms. Hansman, who might be speaking for the defense? Okay, Ms. Hansman, have you had the chance to review that pre-sentence investigation with your client?
I have, Your Honor.
Any corrections or amendments you wish to note?
No, we would simply ask that the letters as well as the impact statements that were submitted to this court by email be included within the pre-sentence investigation report.
All right. And Mr. Sample, you got a chance to review those as well?
I did.
All right, and the court will do so. Any reason for delay in sentencing on behalf of the defense?
No, Your Honor.
All right. Folks, just to kind of give you an idea how we're going to schedule this, what will happen is initially the state will give various statements and or present witnesses to testify about the facts and how this case came about and the perspective. It won't be regarding community conscience. That's improper, and it'd be about, though, and what I mean by community conscience as far as testimony is about how it may have impacted others in the community. That's for my determination and weight. And I, as I've indicated to counsel, we're going to try to focus on, the events that took place, how they came about, and then the court will hear information in aggravation for purposes of argument, and then also we'll hear information and testimony for mitigation purposes. This is an open plea to manslaughter in the first degree. Back in 1981, when this event occurred, we have to apply the law from then, not the law now, but essentially it's about the same, has about the same impact, meaning that the open plea to that charge stands with it up to life in prison or anything less than that. And by less than that, that could mean no time at all. And so that's completely within the discretion of the court. There's been comments and commentary about whether the discretion should be exercised or should be limited. That's a question for the legislature and not for the court and not for these parties here. That's the agreement they entered. They presented it to this court. This court agreed to accept that agreement, and with those understandings is that it's an open plea. And so if you're not happy, be unhappy with me, and don't be unhappy with the attorneys, law enforcement, or anyone else. This decision came upon me and me solely, and I accepted that when I decided to take the oath to be a judge. And so I know there's going to be people here that will not like some things I say, will disagree with me, may agree with me, but that's understandable. And that's the great thing about our country is we can have agreement and disagreement, but hopefully continue to live in peace with each other and respect each other and the reasons for the decisions we make, including, you know, the decisions the state made in bringing the charges and what they did, the decision the defense has made, and the reason they entered into the agreement, and for all those reasons. So with that, we will take a break after the state has concluded its presentation of the information. And that's to allow for us to have a Zoom connection with witnesses of the defense. And then once the defense is completed with their presentation of the case, the state will have the opportunity to provide any further rebuttal information and or argument. At that point, I'm not certain where it'll be, but we'll probably take a break. At that point, the court will collect its thoughts, considerations of all the information that will be further presented. I have reviewed everything that's been presented to me multiple times. And the court has reviewed the law not only from 1981, but even to a certain extent, the law as it has developed. What's unique about this case, it is a cold case, and the technology, the science, the medicine in 1981 is obviously not the same as the technology, the medicine, the science here in 2021. And so a lot of that had a part to play in where this case is now. So we're going to hear about that. And so I don't know if these breaks will occur all in the morning session or if some of it will occur over the lunch hour and then we come back. And but anyway, I wanted to give everyone kind of a roadmap where we're at. So with that, any questions you have, Mr. Sample, before the state presents its information?
No, Your Honor.
Ms. Hansman, any questions you have for the defense?
No, Your Honor.
All right. With that, any witnesses you wish to call, Mr. Sample?
Yes, Your Honor. State would call Lee Litz.
Mr. Litz, please come forward over here to the stand. You don't need to swear. Go over here, Mr. Litz. We're not going to swear you as a witness here. We're just going to have you present information, okay? I would ask Mr. Litz, go ahead, pull the chair out, have a seat. The microphone, you'll need to kind of move it towards you, and it does move. That way everyone can hear you very well, okay? The other thing I'd ask that you do, we have our wonderful court reporter sitting here, and she can only take down one of us at a time talking. So when Mr. Sample's asking you questions, please wait till he's done, and then give your response. And then Mr. Sample knows that he has to wait till you're done before he asks the next question, okay? And if you get emotional and start speaking rapidly, slow down and just take a big breath, and then we'll move forward, okay?
Okay.
All right. With that, Mr. Sample.
Mr. Litz, would you please state your name
Lee Allen Litz,
and spell your last name if you
Litz.
And you recall the events of February 28th of 1981?
Yes, I do.
And on that date, did there come a time in which you found a body?
Yes, there was.
And how did that take place?
Yeah, me and three friends were out test driving in an old International Scout a friend of mine had bought, and we pulled into an approach on around approximately 33rd and Sycamore. And we're just test driving, all we were doing, and we seen them blankets laying there, and my curiosity got the best of me, and I went over to see what it was, and that's when I found Andrew laying there with his back to me.
And at that point, what did you do?
I went back to the scout and told the guys what I'd found, and we went over to Chuck Schulte's house and called the police.
How long was it, you think, before the police showed up?
Oh, probably 5 minutes, if even that.
Did you go back to the scene with the police?
Yes, I did.
I don't have any further questions, Your Honor.
Any questions, Ms. Hansman?
No, Your Honor.
Mr. Sergeant? Okay, thank you. You may step down. Thank you, sir.
Thank you.
State will call Michael Webb.
Please come forward. And again, I don't believe there's any necessity for swearing of this witness. Would you agree, Ms. Hansman, Mr. Sergeant?
No objection, Your Honor.
Okay. Please have a seat.
You please state your name for the record.
Michael Webb, W-E-B-B.
And how long were you a detective?
16 years.
And when did you start with the police force?
February 1994.
And did there come a time when you went into the detective division, crimes against persons?
Correct.
And how is it that you became involved in the baby Andrew case?
Simply by accident.
So it wasn't assigned to you?
It was not.
So what's the accident? How did that happen?
We had moved from the public safety building to the new law enforcement center and carting all those boxes and trucking stuff over. I had gone to our secured records area looking for a different case or some documents, and on a top shelf in the back of a storage room was an old weathered box that someone wrote murder on the end. My curiosity got the best of me. We pulled it down, and I was aware of some cold cases. Luckily in our community we have very few. There was one file in there that was extremely small, maybe 30, 40 pages. Homicide books can be 300 to 400 to 3,000 to 4,000. I started reading it, and I was unaware of this child that had been murdered in '81.
And so at that point, you just took the case on?
I did. Again, it intrigued me as an investigator, and not knowing anything about this case. Brought it back to my desk and ended up bringing it home that night and reading it.
Okay. So at that point, did you see whether or not there was any physical evidence left from this case?
I guess the investigator mind kicks in because there was, in that very, very short report, there was evidence. And granted, we're talking 2008, 2009, but there was already DNA and some pretty good technology back then, and we thought, hey, I think we can solve this.
Okay. Was there any physical evidence from the scene, the blanket, the panties, the shirt?
In the report, there was mention of all that in the evidence room.
Did you make any effort to locate that?
I did.
What did you find?
I found that it had been destroyed in the mid-90s.
So at that point, you have these reports to go off from. What did you do?
You start from square one, review all those reports, but frankly, this was a very unique case in that those reports did not jump out anything factual to even start with.
So it's fair to say that the investigators at the time followed whatever leads were available?
Very, very few leads, but they did.
So at that point, what do you do?
You continue to think about it. How do you solve this? It was an incredible, devastating roadblock to find that things had been destroyed that we could test today. I, again, maybe by accident or luck, met with some investigators in Chicago, Illinois, who were investigating cold cases. And I learned a President's Initiative through the University of North Texas got a federal grant on an unidentified missing persons lab. That started phone calls to that angle to see if that fit our the parameters for what we had with this baby.
And did it?
It did.
And so at that point, what did you do?
The problem at that point was, again, lack of evidence, and the only thing that these folks at North Texas could do was try to extract DNA from the body itself.
And so at that point, did you have the body exhumed?
We did extensive research. I didn't know anyone who had done an exhumation order. That had to be talking to investigators from across the country that have done this. And eventually we were granted an exhumation order, and we ended up bringing Andrew out.
And was the lab in Texas able to extract DNA from Andrew?
They did.
So at that point, what do you do?
Another probably roadblock, but there's little you can do with that DNA at that time. There was not policies in place. So we had a DNA profile of the baby, of our victim. But how do we search that against any databases?
How did you solve that roadblock?
Our state lab got involved. They bent over backwards, and we ended up researching other state labs across this country, a lot of phone calls and research. The Attorney General's office got involved in changing the legal wording on policies. That took almost 3 years. And eventually policy was changed, but we were only able to search it in the South Dakota database.
Okay. And so how often was that search done of the South Dakota database?
It was done initially, and then the new policy said it could be done every year in February.
And that database is comprised of what?
Certain felons, but only certain convicted felons.
And so was that ever fruitful in finding the defendant?
In the big picture on whoever the parents were to this baby, that sample size was extremely small, and we're only limited to South Dakota, so no.
How is it that you got beyond that? How is it that you were able to search a database that would provide you with that trail?
Time needed to go on, and new technology, and some major cases, and a lot of phone calls to investigators who were working major cases that were coming up in the news. One in particular in 2018 was the Golden State Killer. Somewhat similar to what we were looking for, searching DNA databases. So some phone calls and speaking with them, we identified a private lab on the East Coast that could also worked in identified human remains.
And which lab was that?
Parabon.
Okay. So at that point, what did you do?
Pleaded with the city for money to research this, and contacting Parabon to learn what can they do for us. Does our case fit their parameters?
And so as this case went on and progressed, was getting the funds to continue to investigate always an issue?
It was an issue for 10 years. We just simply didn't have that in a budget. And again, luckily we don't have many cold cases, but there's not a cold case section. This is done on our own time.
Okay. And so what did you get from Parabon?
They were able to, the lab in Texas still had enough DNA sample, so they connected, and they have connected in the past, obviously being in the same business. We were able to get that DNA profile to Parabon, who established a genealogy start of a family tree.
And what does that mean, a genealogy start?
They were able to research certain family tree databases that are out there. And again, we're still a long shot because it could be a fifth cousin twice removed, whatever that even means. But we did get a phone call that someone in Arizona had submitted a sample trying to look for their real mother, and it ended up being a similar profile to Andrew.
And so when you say similar profile, that was the starting point?
It was.
And so at that point, What did you do?
We took that information and extensive isn't the right word, but Detective Mertis bought all kinds of public search sites, searching obituaries, birth records, things from the early 1900s, trying to build a accurate family tree. What we found from Parabon of interest was that most of this family came from the Sioux Falls area or the Hutchinson County, South Dakota area, so it was actually very local.
Okay. And so at that point, what did you do?
We ended up finding a woman who very closely matched into the family tree. In researching her, we saw that she had children that would have been about the age of someone that could have gave birth to a baby in 1981, and one of them lived here in Sioux Falls.
And who was that?
Theresa Bentaas.
And so at that point, what was your expectations?
Still extremely low. What is this? Is it a third cousin? I don't know my third cousins. It still was a potential huge roadblock. But the next step is to try to get that family tree more accurate and closer. So we're taking steps to get to that point. So getting the DNA from Mrs. Bentis was important and continue to build the family tree.
And so how was that accomplished?
By detectives finding the residence, and they did a trash pull.
And what does that mean?
Trash is put out on a certain day. It's off the legally being able to pull that trash to find a vessel, in this case, beer can, cigarettes, something like that. Again, at the advice of the state lab on what they need to extract DNA. That was completed. Some items were sent to our state lab.
And once the state lab got it, what did you learn?
We learned it wasn't a third cousin twice removed. Frankly, surprisingly, it was the same profile, baby Andrew's profile, as the mother and the father.
And so at that point, what did you do?
At that point, I did interview Mrs. Bentis.
During your interview, did you ever ask her why she did what she did?
Many times.
And how did she respond to that?
I don't know if there really was a definite answer. It was more, I was young, I was scared.
At the point that you identified Miss Bentis as the mother, how long had you been investigating this case?
10 years.
And during that time, you had your normal standard caseload every day?
Correct.
This was just something you did above and beyond, is that fair?
Correct.
Thank you. I don't have any further questions, Your Honor.
No questions, Your Honor.
Thank you, Mr. Webb.
Thanks, Judge.
Additional witnesses?
No, Your Honor, I just have an argument.
Okay.
Judge, I know that in a case like this, whatever decision you make is not going to make everyone happy. And the people who want to do away with the manslaughter in the first degree, which allows for a life sentence, will take away the opportunity to resolve a case like this. And I hope they don't change the law. Here as it stands today, you are free to impose whatever sentence that you deem to be appropriate, up to and including life. There are mothers that believe that this should be a life sentence. I also know that the family doesn't want anything done. If she's just let go, then what is the value of life? And what does it say about our society? This case is different from your run-of-the-mill homicide cases for many reasons, not the least being that it took almost 40 years to solve. It is also different in that the victim here has no voice, no one who shared a life with him, who knew all the victim's characteristics and personality, and to speak on his behalf about how he affected their life or impacted them. Usually those folks are family members and close friends who've shared that life. Here, because of the defendant's decisions and actions, no one intimately knew baby Andrew. And because of what this defendant did, no one ever will know baby Andrew. So today we'll hear about how the family wants nothing done, and we should just call it good and move on. I learned a long time ago that justice and the law are rarely, if ever, the same thing. She has accepted legal responsibility with the Alford plea, but still holds on to the claim of not admitting guilt. I tell juries all the time, in every case, that there are questions that are never answered. That is true in this case. We will never know why. When Detective Webb asked her, she responded, "I was young and stupid." She never actually answered why she did what she did. In all probability, we will never know why. This case is also different in that the one person in all the world who we expect will be with us no matter what comes our way is our mother. In this case, that very person is the one who deprived him of life. It is also different in that 5 years later, when her daughter was born, the exact same scenario was set up. No one knew she was pregnant. She again hid it from those closest to her. She gave birth to the child alone in her bed at her mother's home. But in that case, her stepdad and mother, hearing her struggle during the pains of childbirth, came and helped with the baby. As much as we may want to believe that this does not reach beyond one family, it did affect others. Mr. Litz, finding a body would rattle most people. I have no doubt that finding an abandoned deceased child would haunt someone forever. I also wanted the world to know the diligence of Detective Webb. He is the only reason why we are here today. He took a case that everyone else had given up and worked it for 10 years. It is also important to know that this case was not solved because this defendant had a crisis of conscience and came in and said, "Hey, here's what happened." The sentence I'm asking for does factor in what the court must consider when fashioning someone's sentence: rehabilitation. Whatever sentence you give in this case, we concede she lived a good life. We know she was not involved in the criminal justice system. She raised a family and was, by all accounts, a good mother and a good citizen. Deterrence. If nothing else is done, doing nothing deters no one. I believe it sends the wrong message to society about the value of human life and rewards keeping what you did a secret. Retribution and punishment. Her actions resulted in the death of baby Andrew. He deserved the chance to experience all that life offers, the chance that he was deprived, the chance to live a life. No one had the right to deprive him of that opportunity. Punishment is as important as any other factor in sentencing. I am not here today asking the court to impose a life sentence. I am asking that you impose a 40-year sentence. Under the sentencing scheme of 1981, she would have to serve 25% of that before she could be paroled. In essence, it would be a 10-year sentence. She is 60 years old, so she could be back with her family by the time she's 70. The 40 years imposes a punishment for what she did and allows for her to return to her family. I do believe that there should be a consequence for not giving baby Andrew a chance. Discarding him in a ditch, covered by a blanket, leaving him for a stranger or animals to find, nameless and alone. Baby Andrew deserves justice, and that should be factored in when you sentence the mother who left him there like a piece of trash. Thank you.
Thank you, Mr. Sample. With that, we'll take a recess so that we can set up the Zoom and then start with the defense presentation of the case. For those of you that are here in the courtroom, I will only caution you, if you leave, you may lose your spot. And so these are not reserved seats. Again, though, this is being live broadcast by audio through various outlets. And so if you do choose to leave and can't get back in, you can access that media for purposes of continuing your involvement in this case. With that, how much time do you think you'll need to probably set up for your witness? 20 minutes?
5 to 10 should be sufficient.
Okay. And I have to get don't know if our tech person's here to open it up, so we'll have to get her here too. So we'll be in recess. Ladies and gentlemen, the other thing I just need to remind you of, and I haven't spoken to the media outlets, but I think the mics remain live, and I don't know if Mr. Hanson, he's shaking his head in the affirmative. What that means is anything you're saying, everybody out there is hearing, okay? So just keep that in mind, because that means I can be listening too. Shocker, huh? But the court does listen, all right? All right, with that, we're in recess.
hear us?
Thank you for standing.
Please be seated. All right, we are back on the record after having taken a short recess after the state had presented its primary arguments for sentencing. It's now time for the defense to present their information and our arguments. Ms. Hansman, are you calling a witness in this matter?
We are, Your Honor. We would start with Dr. Cara Angelata via Zoom.
Dr. Angelata, would you please raise your right hand? Do you solemnly swear the information you're about to give in relation to this matter be the truth, the whole truth, and nothing but the truth, so help you God? Okay, just hang on one second. I think you have to unmute your mic.
I'm sorry, Your Honor.
Okay. And for the record, what was your response to the oath?
I do.
All right. And we have a court reporter that's taken down everything that's been said in Zoom, as we know is not perfect. And so make certain that you speak slowly and clearly so that we can get the record down. With that, Ms. Hansman, you may proceed.
Good morning, Dr. Angelata. Are you able to hear me okay?
Yes.
Would you please introduce yourself to the court?
My name is Cara Angelata.
What do you do for a living, Dr. Angelata?
I am a psychiatrist.
What type of education and training do you have?
I went to medical school at Northwestern University. After medical school, I attended a 4-year training program it's called residency in psychiatry at Cornell University. Following residency in psychiatry, I did an additional year of training, a fellowship in forensic psychiatry at Columbia University.
Where are you employed at this time?
I'm employed in Chicago at Northwestern Memorial Hospital and at the medical school here, Northwestern University's medical school.
What is your role there?
I wear a few different hats. I'm the director of psychiatry training for medical students, and I'm also the fellowship director for our program in forensic psychiatry. And clinically, I treat in inpatient settings in our hospital as well as an outpatient.
What were you hired to do in this case, Dr. Angelata?
I was hired to do a forensic psychiatric evaluation of Miss Bentis related to her mental state at the time of her son's birth and to assess for any relevant psychiatric factors if they may have been present at that time.
Are forensic psychiatric evaluations a standard part of your practice?
Yes.
How many have you done?
I'd estimate I've done between 50 and 60 over the past 5 years or so.
Can you explain what exactly is entailed in a forensic psychiatric evaluation?
A forensic psychiatric evaluation starts with a review of any collateral records, materials relevant to the time period in question, as well as dating prior to and following the event in question. And then a comprehensive forensic psychiatric assessment where the forensic psychiatrist takes a very detailed history. In a criminal matter, it would start with a background history, developmental history, starting even with the person's mother's pregnancy with them, and then going through childhood, reviewing school performance, employment history, personal relationship history, any psychiatric or medical history, neurologic history. Then we take a careful history of events and circumstances, symptoms, functioning in the period prior to the event in question, and then during the event in question and subsequent to that. Then I conduct a mental status examination, which is a psychiatrist's version of a physical examination. I may or may not do some psychological testing as part of that assessment. And then I correlate everything I obtained during the evaluation with records that I reviewed as well.
Do you always render a diagnosis following a forensic psychiatric evaluation?
No.
Why not?
Sometimes the person doesn't have a psychiatric diagnosis. Sometimes they aren't any relevant psychiatric factors. They might have a psychiatric issue, but it's not relevant to the circumstances or the event in question, as an example.
When did you meet with Theresa Bentaas?
I met with her in my office in Chicago on February 26th of 2020.
And prior to her coming to your office in Chicago, what materials did you review in advance?
I reviewed her medical records. So there were outpatient records dating back to 1962 when she was a baby, hospitalization records dating back to 1986. And then I also reviewed the police file, so the police investigation, including the audio recordings of the interviews that the detectives did with Miss Bentis, Mr. Bentis, and her roommate, as well as the autopsy report.
Why is it important to review those materials before you meet with a patient?
So it's important for me prior to any psychiatric evaluation, forensic psychiatric evaluation, to review all the records because I want to have a good understanding of what happened. And I also, when I'm doing the evaluation, want to make sure I'm listening carefully for consistencies or inconsistencies with the records from the case.
How long was your in-person meeting with Teresa?
We met for about 4.5 hours.
And what topics did you all discuss during that period of time?
So standard forensic psychiatric examination. So started with her background history, starting with early childhood through the present day, reviewed her childhood, her educational background, her experiences in school, her social history, medical history, any psychiatric history, screening for a history of psychiatric symptoms, traumas, reviewed the period of time prior to and during her pregnancy with her son, the period of the delivery and period immediately following that, her subsequent pregnancies, a mental status examination, and then I did a psychological testing at the end.
After this in-person meeting with Teresa and following the review of her medical records, the police reports, and all the other materials that you reviewed as part of this case, did you come to a psychiatric diagnosis for Teresa?
Yes.
And what is that diagnosis?
Complete pregnancy denial.
And is that diagnosis of complete pregnancy denial, is that to a degree of medical certainty?
Yes.
What exactly does it mean to be suffering from complete pregnancy denial?
Complete pregnancy denial is a condition where a person does not recognize their pregnancy. In complete pregnancy denial, a person doesn't recognize the pregnancy until intrapartum. So intrapartum is the period from the onset of labor until after delivery. So sometimes a person may first realize they're pregnant when labor starts, but sometimes it goes as far as they don't realize they had been pregnant until after the baby was born.
Is this a psychiatric condition?
Yes.
How frequent does complete pregnancy denial occur in the population?
It occurs in 1 in 2,500 pregnancies, which is 3 times more common than triplets, to give context.
And how do you know these statistics? What is that based from?
Peer-reviewed scientific literature. So there have been epidemiologic studies of pregnancy recognition in several different countries that all point to a 1 in 2,500 occurrence of complete pregnancy denial.
What are the statistics insofar as this diagnosis of complete pregnancy denial and experiencing a home birth?
So about 1 in 10,000 pregnancies are recognized intrapartum and associated with a home birth. So a complete surprise delivery at home, typically unassisted with no one else around.
In those situations, are there additional statistics as far as baby survival or issues that occur during such a birth?
So even in pregnancy, complete pregnancy denial, where the pregnant person presents to the hospital, understanding that there's something wrong with their abdomen, and the pregnancy is diagnosed in the emergency department, for example, even in those cases, there's high rates of neonatal poor outcomes. For those babies born in the hospital with complete pregnancy denial are more likely to have problems with breathing, more likely to have what we call low APGAR scores. So that's the measure of what the baby's color is, what their heart rate is, how they're breathing, their respiratory rate after birth. Babies are more likely to be admitted to the neonatal intensive care unit, the NICU, after an unrecognized pregnancy, even when they're delivered in the hospital. And stillbirth rates are reported in studies to be from anywhere between 1.5% of complete pregnancy denial pregnancies resulting in a stillbirth to up to 8%.
What are the characteristics of complete pregnancy denial?
So typically, the pregnancy, well, in all cases, the pregnancy is not recognized. The person in retrospect reports either not experiencing or misinterpreting the typical signs of pregnancy. So often the woman will report that her period, her menstrual cycle has always been irregular. So she didn't notice that she hadn't had her period in some time, or may misinterpret vaginal bleeding during pregnancy, which can happen in normal pregnancies, as a period, as spotting. Women will often report not gaining weight, or if they do gain weight, it wasn't much weight, or they attribute it to other causes like unhealthy diet or stress or something like that. The people in the woman's life don't notice the pregnancy typically. They don't ask about it. They don't appreciate it. Up to 60% of women in some studies have a partner that they live with when they experience pregnancy denial, and that partner also doesn't recognize the pregnancy. In some studies, up to 40% of women have gone to a physician during the pregnancy, and the physician does not recognize the pregnancy, with some extreme cases like a woman seeing like a colorectal surgeon for hemorrhoids, which are common during pregnancy, and that surgeon not diagnosing the pregnancy, even though they're examining their abdomen and their rectum, as an example. So the pregnancy itself is different. The person doesn't notice fetal kicking. They don't develop the typical silhouette of a pregnant abdomen. Strangers don't notice the pregnancy. And then the experience of labor is very different. Labor comes as a shock, a surprise. Often the onset of labor is misinterpreted as either having to have a bowel movement, and sometimes these women who experience this deliver on the toilet thinking that they're having to have a bowel movement, and in fact they're giving birth. Sometimes it's interpreted as the onset of a menstrual cycle. Women with irregular periods often have quite painful menstrual cycles, and so they misinterpret labor as a period. Some women report that the labor is relatively painless, which can be a symptom of dissociation. The labor itself, in complete pregnancy denial in particular when it occurs at home, is often precipitous, which is the medical term for meaning the labor is fast, quick, proceeds very quickly. And then when they see the baby, some women when they see the baby is when they realize they had given birth, and they're in a state of shock. Dissociation symptoms are quite common. Dissociation is when the normally integrated mental functions like emotion, cognition, sense of time, memory are disrupted. So women will report things like they don't remember how long it took. They're not quite sure what happened. They haven't significant impaired memory for events. They might feel like the world around them was unreal, like an extreme sense of a surreal experience, or like they're watching themselves like they're in a movie from outside their body. Some women report auditory hallucinations, like hearing voices, even though they don't have a history of psychosis during this experience. So these are some of the common symptoms that are consistently reported among women who've experienced an unrecognized pregnancy and give birth.
In your medical opinion, what evidence supports Ms. Bentis's diagnosis of complete pregnancy denial?
So Ms. Bentis did not recognize her pregnancy with the baby. She doesn't recall. Her first recollection of knowing she had been pregnant is after she'd actually given birth. During that pregnancy, she reports minimal weight gain, if any memory, no real memory of any weight gain during that pregnancy, which is consistent with the contemporaneous medical records from that time. She reports a history of irregular periods, again, consistent with her medical records from that time, that she wasn't somebody who had a typical 28-day menstrual cycle. Her mother, who she was close with, didn't know if she was pregnant, according to what she told the police. Her roommate did not know she was pregnant, who she lived with. Ms. Bentis reported that no one asked her if she was pregnant. Her experience of the labor itself is quite typical of a case of complete pregnancy denial. So she reports she was woke up from sleep due to abdominal pain. She thought it was muscle cramping, which she has experienced off and on over the years in her abdomen. And again, her medical records corroborate that she had experienced muscle cramping in her abdomen. So there's records from around that time period that show she'd gone to the doctor with abdominal muscle cramping and had been prescribed muscle relaxants at one point in the years around that time period. So she thought she was having muscle cramping, reports kind of a sudden period of pain, which in retrospect she realizes is when her water broke, and then seeing the baby on the bed. And she described the baby as lifeless, as ghost-like, and being in a state of shock. Her memory for this time period is quite impaired. That's common in people who experience a major trauma, a major shock, for them to have what we term dissociative amnesia, which means that their autobiographical memory for the period around the trauma and the trauma itself is impaired. They might have partial memories or incomplete memories, or some people even have no memories. So all of these experiences that she reported, the sense of not knowing what her thought process was, what she was thinking, that she reported to the police, are all consistent with a textbook case of complete pregnancy denial.
Dr. Angelata, if somebody experiences complete pregnancy denial once, can it happen again?
Yes, it can. So in studies of women with complete pregnancy denial, for example, in one study that asked this question that's in the published literature, 8% of the women had had a prior pregnancy denial. Conversely, a person can also have a normal pregnancy and then experience an unrecognized pregnancy. So both can happen.
Could Teresa have simply told you what you needed to hear to make this diagnosis?
No.
Why not?
So when I do a forensic psychiatric examination, it's different than a clinical situation. In a clinical psychiatric interview, you have a common understanding that the person is coming to you for help with symptoms. They're your patient, you're their doctor, you're treating them. And so you take what they say as at their word. They're making their best effort to tell you what you need to know so that you can make an accurate diagnosis and treat them. A forensic exam is different. In a forensic exam, my ethical duty is to be objective and tell the truth to the court or the person who retained me so that they have accurate information for the purpose of making legal decisions. So our techniques are different, and our alertness for malingering, which is faking psychiatric symptoms for some secondary gain in a criminal case, for example, getting out of criminal responsibility. So we have to pay careful attention to that assessment. So as part of that, we're carefully correlating what a person says with known psychiatric phenomenon with available records, collateral sources of information, and also with careful assessment for malingering. So, for example, a person who's faking psychiatric symptoms will often report extreme versions of cases and of the symptoms, and will report, for example, like every possible symptom of that condition, which generally is not how conditions present in real life. So that's something I listen for. Another thing I do is a assessment for malingering, a formal psychological test, which I did in Miss Bentis's case, which was negative for malingering.
Dr. Angelotta, is it your expert opinion to a degree of medical certainty that Theresa Bentis suffered from the well-established psychiatric condition of complete pregnancy denial throughout her pregnancy with Andrew?
Yes.
And is it your expert opinion to a degree of medical certainty that Teresa suffered from the well-established psychiatric condition of complete pregnancy denial at the time of Andrew's birth on approximately February 27th of 1981?
Yes.
Thank you for your time. I have no further questions.
Ms. Johnson.
Thank you, Your Honor. Dr. Angelotta, you only met with Miss Bentis on one occasion, is that correct?
Yes.
And in your report, you outline the materials you reviewed prior to meeting with her. Did you ever speak to Mr. Bentis?
No, I relied on the police interview of Mr. Bentis.
Would an interview of her spouse, someone who would have been around her at the time, been something that would have been beneficial for your report as collateral information?
It wasn't necessary because the police spoke with him.
Okay. What about Paulette Fisher, her mother?
Again, the police spoke with her mother, and I relied on what she told the police.
And you also spoke to Miss Bentis,
Yes.
and you also reviewed the information she provided law enforcement.
Yes.
And some of the information she gave you was different than what she told law enforcement.
Not in ways that were significant in my review.
Well, she talked about shame and not wanting anybody to know she was pregnant to law enforcement, correct?
She didn't talk about not wanting anybody to know she was pregnant.
In footnote 5 of your report, you note in the 4th paragraph that she never discussed his birth with anyone because of the shame, and she did not think anyone knew she was pregnant.
Yes.
Okay. And when she talked to you, she denied ever knowing she was pregnant prior to giving birth.
Correct.
But she doesn't remember large portions of it.
Correct.
So when you're examining malingering, do you take into account that her amnesia was kind of self-serving?
Of course, I consider the possibility that a person could be pretending not to know something to avoid criminal responsibility.
And she remembers some things about the birth of Andrew, correct?
Yes.
She remembers that he was ghost-like, that he was pale, that he was not crying.
Yes.
Things that seem to support her statement that he didn't appear to be alive.
Not only do they support that statement, they're consistent with the autopsy report, which shows a likely short duration of survival.
But then she doesn't recall anything about her putting him in a ditch.
Correct.
She doesn't recall wrapping him up in a blanket.
Correct.
She doesn't recall anything that talks about her disposing of her child in a ditch, because she doesn't remember those portions. So she remembers the portions that are consistent with an autopsy report, but doesn't remember the portions that maybe make it look not so good.
She has an amnesia for significant portions of what occurred.
But she remembers the parts that match with the autopsy report of him being pale, him being ghost-like. She remembers that.
Not only do they match with the autopsy report, it's consistent with medical literature about what happens in these pregnancies.
And these pregnancies are the complete pregnancy denial pregnancies, correct?
Yes,
And you would agree with me that complete pregnancy denials, complete denial pregnancies are more common in cases of neonaticide, correct?
yes,
Cases where children die within 24 hours of birth because of either somebody killing them or someone failing to care for them.
correct.
Well, let's talk about your reasons for why you believe that Ms. Bentis was suffering from your diagnosis of complete pregnancy denial. Your first basis was that she lacked definitive knowledge of the pregnancy prior to delivering Andrew. But that was also that she didn't seek any medical care for that period of time, correct?
I'm not sure I understand the question.
Basis number one, she didn't receive any medical care for her pregnancy with Andrew because she didn't know it existed.
So there was no medical records to document that she had been diagnosed with pregnancy or that confirmed that she knew she was pregnant during that period, which supports her recollection that she didn't know she was pregnant.
She also received no medical attention or medical care during her pregnancy with Melissa, correct?
Yes,
And she knew she was pregnant with Melissa.
yes,
In fact, she knew she was pregnant with Melissa early on because she recalled suffering from morning sickness.
I'm not sure that she knew early on because she mistimed her pregnancy with Melissa. So it's not clear when she recognized she was pregnant with Melissa. She certainly thought she had more time with the pregnancy.
But you noted that she suffered morning sickness with Melissa?
She reported morning sickness with Melissa, which was part of how she knew she was pregnant.
And you also indicated in your report that morning sickness is often a symptom of an early symptom of pregnancy?
It's often an early and one of the first symptoms that people notice of pregnancy, but as most people who've experienced pregnancy can attest, it often lasts throughout the pregnancy. So simply because someone has morning sickness doesn't mean that you're necessarily accurately timing the pregnancy.
Did you ever ask her when she began to realize she was pregnant with Melissa?
My exact recollection for what is that she wasn't sure exactly when she recognized the pregnancy with Melissa, but she was certainly surprised by the onset of labor. She thought she had more time.
You note that she has irregular menstrual cycles, also a symptom of pregnancy denial.
Not really a symptom of pregnancy denial, but a common reported characteristic that women who go on to experience an unrecognized pregnancy report. So frequently women with unrecognized pregnancies will report a history of having had irregular periods.
And she continued to have irregular periods during the pregnancy, leading up or prior to her pregnancy with Melissa and prior to her pregnancy with Justin?
I'd have to look back at the exact date. So there was times that the medical record showed that there were periods where her periods seemed to be more consistent, and then other times where there would be stretches where she would go without reporting having had a period.
You note that she didn't recall gaining significant weight. Do you have any independent basis for that information?
For her recollection?
Number 4, under your reasons for evidence supporting pregnancy denial. She didn't recall gaining significant weight during her pregnancy with Andrew.
Correct.
Okay. And then you note that she weighed significantly more in 1978 than she did in December of 81. Correct?
Yes. Yes.
And that was, I think if my math is right, that's approximately 14 pounds. A 14-pound loss in 3 years?
Yes, which is consistent with the other reports about her weight, where her weight was fluctuating in that time period.
Okay. And then one of the other things that you had talked about in number 8 was that there was a lack of awareness of her pregnancy, but Mr. Bentis thought she might be pregnant, correct?
Yes, he reported to the police that he thought she may be pregnant and had never asked her about it.
Did you ever wonder why he didn't ask her about it?
It comes up all the time in pregnancy denial that people, significant others, may consider the possibility of pregnancy but not ask the person about it. So it's consistent with what's reported in these cases.
Her boss also thought she might be pregnant?
From the roommate's recollection, yes.
Okay. So it wasn't that there was a complete lack of awareness. 2 people actually suspected she was pregnant. Did she describe the birth of Andrew as a traumatic event?
She didn't use the words traumatic event.
What did she use?
May I refer to my report so I
Cer-
can be accurate?
Certainly.
She said, quote, "It was like it didn't last terribly long, like pain, and all of a sudden felt something, water breaking, obviously, and then there was a baby. Oh my word, that's all I really remember. Oh, a baby. Of course you're scared. What do you do? That's all I really remember. The coloring didn't look right to me. Pale, not bright or red or crying. Ghost-like to me. He wasn't doing the things I would expect a baby to do, just lifeless. He looked so pale. He wasn't kicking and moving around. It wasn't like Melissa when I had her at home. She was crying from the get-go."
Did she ever discuss then whether she felt guilt or concern after the birth of Andrew?
She described a tremendous amount of shame and guilt that she responded in the way that she did.
Is it shame about the way it happened, or was it shame about being pregnant?
No, not shame about being pregnant, actually. She was clear about that. There was some sense of, the time period. She wasn't married to her partner. But it was the shame that she talked about with me, was the shame about that this had happened, that she didn't recognize the pregnancy, that she didn't respond in a way to the pregnancy, that she had, I think the word she used with the police was, that she wasn't open with this after it occurred. So shame around that, not really the shame around like not being married at the time of the pregnancy.
And so she felt shameful about the way she handled it. And then based on your information, she received and did the exact same things when she was pregnant with her daughter. She hid the pregnancy.
You're misstating my testimony. I don't think she did the same things in her pregnancy with Melissa as she did in the pregnancy with Andrew. In the case of Melissa, she knew that she was pregnant. She thought she had more time, whereas in the pregnancy with Andrew, it's my medical opinion that she more likely than not did not know she was pregnant.
And that's based solely on the information she told you.
And consistent with the collateral sources of information.
And what of those collateral sources of information tell you that she didn't know she was pregnant with Andrew?
So there's no documentation that she had medical visits where she was diagnosed with a pregnancy. Her partner suspected that she may be pregnant, but never even asked her about it or spoke to her about it. So her boss thought that she might be pregnant, according to what the roommate said, but her roommate didn't think she was pregnant, and no one was talking to her about this, which is totally consistent with an unrecognized pregnancy.
Or is it also consistent with a hidden pregnancy?
While that might be true in other cases, it's not true for this case.
And that's based on the information she told you. Correct?
No.
Well, you would have to agree with me, them not talking about pregnancy, between her and Dirk not talking about pregnancy, could be about pregnancy denial, could also be about hidden pregnancy.
It could be.
Because she also hid the pregnancy with Melissa.
Yes.
Okay? They didn't talk about Melissa being pregnant. Or they didn't talk about her being pregnant with Melissa.
I don't think they did. That's my understanding.
And Dirk didn't ask about her being pregnant with Melissa.
That's my understanding, that he was very surprised to hear that the baby had been born.
And Mother didn't ask about her being pregnant with Melissa.
My understanding is the entire family was shocked about the baby's arrival.
And they were shocked when they found out about baby Andrew too, correct?
I don't know. I'd just be speculating.
And she didn't receive medical attention with Melissa either, correct?
After Melissa's birth, she went to the hospital and was admitted to the hospital.
And Melissa was a hidden pregnancy.
She did not share her knowledge of the pregnancy. So there's a form of pregnancy denial that's less severe than complete pregnancy denial called affective denial. And affective pregnancy denial is when a person has cognitive knowledge, so they know the fact that they're pregnant, but they don't emotionally recognize the pregnancy. They think, act, behave as though they're not pregnant. And it can be that they're concealing the pregnancy. It can be that for large periods of time that they're just not kind of denying to themselves that what they know to be true, the pregnancy. And sometimes it can happen, like it happened for Miss Bentis, that the pregnancy itself, they mistime it, and when they give birth, they're surprised that they're going into labor.
She told you that she, following the birth of Andrew, I believe she said somewhere in your report that she prayed to God and she's sought counseling with God.
Yes, she told me that she's a religious person and prays regularly.
Did she talk to you about praying specifically in regards to baby Andrew?
Yes.
Did she tell you whether she ever held baby Andrew after he was born?
I don't recall us specifically talking about that.
Did she ever tell you she swaddled him?
My recollection is that she didn't recall what she did or that period of time around there. I know he was found swaddled, so she clearly did, but I don't think that she recalls that.
Did she ever recall touching him at all?
She doesn't remember doing that, is what she told me.
Did she give him a name?
She referred to him as Andrew when she spoke with me, and it was my sense that she's accepted that as his name, which my understanding is not the name she gave him, but the name the church gave him.
Did she ever name him?
I believe I just answered that question.
I think you said that was not the name she had given him. Did she give him a name?
Well, I'm telling you that the name she uses for him is Andrew.
So she never named her son?
She accepted the name the church had given him, yes.
I don't have anything further.
Just briefly, Dr. Angelata, is it surprising to you that Teresa remembered details of the birth itself and then had no recollection of the subsequent events?
No, it wasn't surprising to me because it's consistent with dissociative amnesia that's reported in these cases. It's also consistent with how she's experienced other traumatic events in her life. For example, she didn't have a lot of recollection around the time her dad died when she was in third grade. Remember general pieces of that time period, but not a lot of specific memories. A lot of people in trauma don't keep their memories very clear.
I have no further questions. Thank you.
Thank you, Doctor. With that, we will conclude the Zoom connection. So on your end, if you want to disconnect, I'll be disconnecting on my end. Thank you.
Okay, thank you, Your Honor.
Are there going to be any other Zoom witnesses or anything?
No, Your Honor.
Right. With that, you may call additional witnesses.
We would call Michelle Fisher, Your Honor.
Please come forward, Ms. Fisher. Go ahead and have a seat there. I note that you have some paper in front of you. You might be reading a statement. If you do read it, please read it slowly so our court reporter can get everything down, okay?
Okay.
Ms. Hansman?
Ms. Fisher, before you begin, I'm going to have you spell your name for the court reporter.
Okay. Michelle, M-I-C-H. M-I-C-H-E-L-L-E.
If you wish, we can take a short
sorry.
recess. No, that's okay. If you wish, for you can collect.
No,
your
I've
thoughts.
got it. I've got
Okay.
it. I can do this. Last name Fisher, F-I-S-C-H-E-R.
Ms. Fisher will be making a statement. It will not be a back and forth exchange. She just has a statement she would like to share with the court at this time.
Right, thank you. And again, Ms. Fisher, if you're reading the statement, please read it slowly
Okay.
and carefully. Okay, thank you. Go ahead.
Hi, Judge Zell. Thank you for your patience. Thank you for allowing me to speak today. My sister, my sister is Theresa Bentaas. Many people might think that they know her simply from hearing her name in the media or seeing it on a legal document. They do not. They do not know what is in her heart. They do not know what lies within her soul. They do not even know something as simple as her favorite color, favorite holiday, or favorite food. They do not know her from the inside out. I do. A person cannot know a life lived just by simply knowing one's name. It would be impossible to know the fabric of her heart or the quiet thoughts that lie deep in her soul. Today, I want to share with you the person behind the name. I want to share who Theresa Bentaas is to me, to my family. Teresa is more than a big sister to me and has always played the role of a second mother in my life. My parents were very lovingly involved, but being the eldest, she got the arduous task of taking care of the baby of the family. I did not always make this task very easy either. She has always rose to the challenge, even to this very day. It takes a special person to be able to understand the nuances of when to be a sister and when to be mom. My sister, Teresa, taught me that beautiful pink skies were the angels baking cookies in heaven, and to never be scared of thunder because that was just God bowling. My second mom, Teresa, taught me to slow down a little and let God's grace in my life. My sister, Teresa, gave me the nickname Mickey and taught me to dance and belt out the song. My second mom, Teresa, taught me to be brave, to stand up for what I believed in, and not to be scared to make mistakes along the way. My sister, Teresa, taught me that she would always be there, no matter what. In 2002, I found out that I was pregnant with my son. I was 27 years old, but unmarried. I was frightened to tell my parents the news. I was scared that they would be so disappointed in me and angry. Being unmarried and pregnant did not align with my parents' beliefs. So I packed up to visit my family for the Christmas holiday, already a few months along. I knew exactly what I needed to do. See my big sister, Teresa, ASAP. She was the first person in my family that I told. I needed advice, love, and lots of moral support. I got every bit of that from her and more. I was so nervous and just blurted it out while we were shopping at the mall. Teresa didn't miss a beat and calmly gave me life-changing focus. She told me that while Mom and Dad might very well be disappointed or upset, those feelings were temporary and the love they had for me was forever. I was reassured that any feelings of concern would fade as the news settled, and their great love for myself, and now my baby, would remain. Then Teresa put her second mom hat on and made sure I had seen a doctor and was taking care of both my health and the baby's health. I left her that day with a sense of calm that I had an ally in my corner cheering me on. I knew that no matter what happened, things really were going to be okay. I knew my big sister was watching over me. Teresa has always been my protector. She scolded me when I needed it, but she was always the first to defend me. She has been a buoy, my soft place to land. There is not a thesaurus large enough, nor with enough words, to adequately look into my heart and see all the beautiful things that I know about my sister, Teresa. It feels like there wouldn't be enough time, space, or words to do her justice. How do you share 46 years of experience in a letter? Judge Zell, I want you to know that Teresa always puts others first and is the first person you can count on in any situation. I want you to know that Teresa crinkles her nose when she laughs and has her eyes closed in almost every family picture. She has been my mom's rock without hesitation or reward. She did it simply because that is who she is to her core. Teresa is kind and sweet and gentle. She never judges and only offers her help and support. Teresa loves unconditionally and with a quiet strength. She never asks anything in return. When my son was young, she always had Matchbox cars and blueberry muffins because those were his favorite things. While he may have outgrown the Matchbox cars, she still makes his favorite muffins. Thinking of others is just second nature to her. Teresa is an amazing sister, daughter, mother, and grandmother. So many lives will be affected by the sentence that is given to her today. In fact, the reality is that the sentence will be served by our entire family. Her young grandchildren will serve this sentence. Her mother, our mother, will serve this sentence. And her children will serve this sentence, each in their own painful way. I beg you to judge her by the life lived and the lives that will serve the sentence along with her. A sentence does not rewind the events of the past, but it does harm the lives of her children and grandchildren that are here today. I know what is inside of my sister's heart without words spoken. I know that she carried her baby with her for the past 38 years in her heart and soul. She carried him in every action, every beautiful gesture, and every good deed done. She carried him in every loving stroke of her children's hair, in every hug and cuddle, and in every hand she held. She carried him in her heart and in her words the day she counseled me on the news of my pregnancy. He has always been with her. If there could be a mirror into my heart, you would see the reflection of my sister. I wish I could put together a highlight reel of her life thus far, so that you might see all the moments in quick delivery of her innate goodness. I wish I could take you on a journey so that you could see everything I see. A journey that would show you how she lived, how she loved, that it was honest, pure, and true. A journey that would show you her kindness, her selflessness, and her family allegiance. A journey that would show you that she is, she was, and she always will be a child of God. Thank you.
Thank you, Ms. Fisher.
I love you.
Ms. Hansman, additional witnesses.
Yes, Your Honor. The defense would call Melissa Philmeyer.
Please come forward. Go ahead and have a seat there and pull that microphone close to you, and then same thing. Make certain you speak slowly and clearly. Thank you. And could you state and spell your full name for the record?
Melissa, Melissa. Last name is Feilmeier, Feilmeier.
Go ahead.
Good morning, Your Honor. My name is Melissa, and I am the daughter of Teresa and the younger sister of Andrew. Andrew is my brother. He is a son. He is a nephew. He is a grandchild. He is a cousin. He is an uncle. He is a brother-in-law, and he is a part of our family. I'm thankful that his birth has come to light and his identity is now known. I love him, and I look forward to the day I get to embrace him in heaven. It is painful to sit in a courtroom with people representing my brother on one side and my mother on the other. It's like I'm being forced to choose between the two, when in fact my heart breaks for both of them. And the heaviness of the situation. This case has taken a very personal family matter and made it into something that gets clicks. Our mom has been falsely villainized in the media throughout this case, so I want to take this opportunity to tell you who Theresa Bentaas actually is. She is a mom. She is Mama B to my college friends and Ma, or Grammy, to her grandchildren. She is a wife, a sister, an aunt, and she's someone's child. I call her mom and she calls me Missy. It's a special name reserved only for her that she has called me since I was a child. She is a working mom who during my childhood worked a full-time job but always put family first. There consistently were hot meals on the table, clean folded laundry, and packed lunches with sweet notes to say I love you. As busy as she was still at every single one of my games, musical performances, and school events, switching her work schedule around to ensure she would be there to support me. She was a room mom and planned countless classroom parties during my elementary school years. In all actuality, she took vacation days from work in order to be involved in my school because it was that important to her. In high school, before I was old enough to drive, she went into work very early so that she could pick me up each day after school. The drive home was an extra 15 minutes she was able to talk with me one-on-one during busy teenage years. She is a believer and a child of God. She exposed me to faith at a young age and gave me the opportunity to learn about the love of Jesus. She took me to church on Sundays and had me involved in religious education, establishing a good foundation I was able to lean on after I left home. Because of my mom, my children are also being brought up to know the love of Jesus. Our faith is based on the principles of love, humbleness, grace, forgiveness, and the importance of family. My mom embodies all of these. She is selfless and puts others before herself. She is warm and welcoming, never prejudges, and gives others the benefit of the doubt. She takes the time to get to know who people are and calls them by name when referencing them. She is kind, patient, and makes others feel seen and heard. She is supportive. She never holds me back, even when I wanted to go to college out of state and when I eventually moved across the country. She continually puts my desires and my happiness above hers and remains steadfast in her support. When I moved away to college, she found little ways to show her love, like shipping large quantities of her famous homemade chocolate chip oatmeal cookies to my dorm room, making her a hit with my friends, and forever enshrining her as Mama B. She is a grandma who tells 3 sweet grandbabies. She tells them, I love you to the moon and back, the stars and back, and all the way to the Milky Way every time they have to say goodbye. Even though her grandchildren are not local, she makes every effort to be a big part of their lives, using little moments to show them how much they are loved. She sends cards for every occasion, big and small, along with messages for each kid encouraging them to have great first days of school or good luck before sports games. She is my mother, and I am thankful to have a mother who loves me and sacrificed herself daily to raise me into a well-rounded woman and provide me with opportunity. Because of my mother, I am the woman I am today. Because of my mother, I am the wife I am today. And because of my mother, I am the mom I am today. These past almost 3 years have been long and difficult for our family. So many emotions have been tied into this situation. Due to the legal process, we as a family haven't been able to fully go through the steps of grief together. In a short period of time, we learned that we have a brother named Andrew, found out that he did not survive, and then lost another family member the day my mom went to jail. My hope is that upon conclusion of this case, our family is able to talk openly with one another, process, grieve, and eventually come to the point of healing. Andrew and my mother are victims of their situation, victims of the culture and the stigma of a young, unwed pregnant girl in 1981. Society failed them back then, but 40 years later, the same narrative and the same shaming cannot continue to take place. From ashes, hope arises, and can start with her being treated like a person, like a mother who needs and deserves to be able to grieve the loss of her child. Thank you, Your Honor, for your time.
The defense would also call Justin Ventis, Your Honor.
Okay, Mr. Bentis, make yourself comfortable and go ahead and pull that microphone up there. And again, as you read that, please make certain that you read slowly and clearly, okay? And please spell your name for the record.
Justin, Justin, Bentis, Bentaas. Good morning, Your Honor. My name is Justin Bentis, and I'm the youngest son of Dirk and Theresa Bentaas. I come before the court this morning in support of my mother, a woman who is the epitome of a model citizen, a loving mother and grandmother, and a strong woman of faith. This morning, I asked the court for leniency. I asked for time served. 30 years ago, my mom gave birth to me. And for 30 years, she has loved and supported me with every ounce of her being. In all things, she put and continues to put me, my sister, and her 3 grandchildren first. I've truly been blessed to have her as my mother. Growing up, I had an ideal childhood. My parents both had held steady jobs. We ate dinner as a family every single night, went to church every Sunday, and spent the weekends traveling to sporting tournaments. Some of my earliest memories revolve around my mom holding me, trying to comfort my first day of school nerves, or calming me down after an especially bad day at school. When she wasn't consoling me, she was pushing me to be the best student, athlete, and person that I could be. Without her loving support, I'm not the man I am today. Early on, my mom and I developed a bond, one that many sons and mothers share. As I'm sure a lot of people can relate, sons inexplicably know when their mom is hurting. And throughout my life, I observed an ever-present pain in my mom's eyes. A pain that mystified me until recently. What transpired 40 years ago shattered my mom. It is a heartbreaking realization, but my mom has punished herself more than anyone will ever know and more than any institution can try. Sentencing my mom to time in prison is simply a punitive decision to appease people that do not matter in this case. It will not make the community a safer place. It will not rehabilitate her. It will certainly not bring any type of perceived justice. It will only cause more pain and suffering for our already devastated family. Many things have weighed heavily on me over the past 2.5 years. The attempts by the prosecution and detectives to convince me into thinking a certain way about my mother, the media's failure to cover this case accurately, the prosecution's fixation on winning the case rather than finding the truth. I could go on. But what has frustrated me the most is that many people seem to think they know what justice is in this case. Let me make this clear. No one except my brother can rightfully say what justice is. The only individuals that can come even close to having some insight as to how my brother would have reacted is my sister and me. I can tell you without a shadow of a doubt that our brother would have reacted precisely how my sister and I did, with empathy, understanding, and most importantly, forgiveness. Judge Zell, I know my brother would have acted with forgiveness, and I ask the court to do the same thing. Let me finish with this. If the court is sincere in trying to deliver the best resolution in this case, you will let my family walk out of this courtroom with my mom and allow us to finally embrace my brother as a complete family. I've been waiting 2.5 years for this moment. My brother has been waiting 40. Don't make us wait any longer. Thank you.
Thank you, Mr. Bentis. Ms. Hansman, additional witnesses?
We have no additional witnesses, Your Honor.
You wish to make your argument now?
I do. For the last 40 years, this community has been told that in February of 1981, someone placed a live, screaming newborn on the side of the road to die in the South Dakota cold. For the last 2.5 years, this community has been told that that person was Theresa Bentaas. That story is scientifically false. So today, that narrative is finally over, Your Honor. In February of 1981, Theresa Bentaas gave birth. She had no idea she was pregnant. The court heard from Dr. Angelata today about the well-established psychiatric condition that Teresa suffered from, of complete pregnancy denial. She did not know But just as quickly as Teresa became a mother that day, she lost her son. Her son died almost immediately. A fact that is supported by the autopsy report, an autopsy report that has not changed since 1981. In a very short amount of time, Teresa experienced two of the most unthinkable moments: giving birth when not knowing, and losing a child. What happened in 1981, Andrew's death, happened to Teresa, not because of her. That distinction is critical. It's a distinction supported by undisputed medical and scientific testimony. And that distinction is critical to how this court chooses to sentence Teresa today. Theresa Bentaas did not kill her child. Theresa Bentaas lost a son. As the court can assume, this is a case that we have been asked about routinely by people on the street, by colleagues. Everybody wants to weigh in. There is a lot of commentary surrounding this matter. And one of the things we hear most was, well, what if she had done that, or I would have done this? And what I tell everyone today is none of that matters. Those what ifs and those maybes, those don't matter. Because we know what the science says. This court made clear at the change of plea hearing what that science says. Andrew was born, possibly took one breath, and he passed away. That is a birth complication. To say she should have gone to the hospital or she could have done this, I understand people's immediate reaction, but what I remind everyone is that it is legal to have a home birth. It is legal to keep your medical information private, including a pregnancy. Theresa Bentaas did not kill her child. Theresa Bentaas lost a son. So the next question is naturally, well, why would she plead to something she did not do? How did we get here? That very complex question actually has a very simple answer, Your Honor. As this court is well aware, you've read all of the reports. Our defense, Teresa's defense, is not one of poking holes. It's one of actual innocence. It's one of truth. It's one of science. But that science-backed defense then came about within a pandemic. So for the last year and a half, we have watched people dialogue about science, some pushback, rejection, distrust. And when you're looking at an indictment that the top two counts carry mandatory life, that science-backed defense, the truth on your side, starts to be even more terrifying. But what made this exponentially worse is the false narrative that we were running into as well. I understand that visceral reaction to what has been out there. I remember the day I was hired to represent Teresa. It's the day she was arrested. And after meeting with Dirk and with Justin, I broke the rule we give all of our clients, and that's don't read the news. I read all of it. I devoured it. Every last thing that was printed that day, I read it. And it was hard, and it was heartbreaking to read. What jumped out to me most, what just wrecked my heart, was the statement that we've read over and over again about those tears on that baby's cheeks. And when I went home that night, I went home to two little kids, one of which was 9 months old and still nursing. And when I looked at him that day, all I could think to myself was, how could she do this? She She didn't, Your Honor. The science proves that she didn't. From the beginning, the science has been on Teresa's side, and yet that isn't what has been out there. Even a simple Google search will tell you that tear ducts don't develop and work on a baby for weeks and months after birth. Even that part was false. So here we are, my client is facing an indictment where the top 2 counts carried mandatory life. We're watching people reject science, and we're going up against a narrative that is incredibly compelling. Was my client confident in the jury system? Yes, absolutely. But my client is not arrogant. My client weighed all of the risk factors against all of the evidence that we had. And Teresa did what she has always done, which is think of everybody else. And I'll tell you that they wanted her to push because they believed their mother all along. And Your Honor, we asked for a court trial on the full indictment, including those counts that carry mandatory life. We asked for that opportunity, but it was rejected. So the Alford plea was the best compromise. Entering the Alford plea allowed Teresa to maintain her innocence and give her the opportunity to share that with everyone else. But she wasn't going to make the arrogant decision to seek vindication at trial against the risk of being convicted because of an emotionally charged case. Teresa made a decision to plead by way of Alford out of love and out of concern for her family members. In this situation, she hasn't been able to protect anyone, much less herself, but that gave her that shred of opportunity to give them some level of protection, knowing full well that even under that plea agreement, that life sentence remains on the table. It was not a decision she came to lightly. But make no mistake, and I know this court understands, but for everyone that's listening, my client has never admitted to killing her child because she did not do that. But yes, she pled by way of Alford and has accepted all of the ramifications that come with a first-degree manslaughter conviction, including whatever this court chooses to do today. There will be lots of commentary, but it doesn't matter. My client made the decision that was right for her family. This court has heard from those family members. I'm not going to attempt to do any better justice to their words. All I would say is that independently, I spoke to Justin and Melissa. And the only thing they didn't mention today was what their greatest concern was. That concern, those grandchildren, and how they will have to explain this to them. It wasn't about themselves, wasn't about their dad, wasn't even about their mom, who they love very much. Their concern was for the generation coming up. If you're looking for an example or an illustration of the life my client has led, you look to those two children. They are a testament to her character and to who she is and how she has always been. Now, this case is a unique one, and the sentencing hearing is no different. Quite often when I appear in front of this court, I'm here explaining my client's level of responsibility and everything they've done to make sure that they don't end up back in front of this court. Here, none of that exists. But there is a shred of it that's still somewhat applicable. This event was when she was 19 years old. So this court is to look at her as that 19-year-old. But this court also has the benefit of the last 41 years of a life incredibly well lived. Dirk Bentis, Teresa's husband and Andrew's father, is someone that you didn't hear from in person today, Your Honor. Dirk, since this happened, wakes up every night at 2 a.m. with his heart racing, his head going a million miles an hour, just thinking about this case, about his wife, about the son he never met, about his children, about his grandchildren, about the financial stress of all of this, the emotional toll he's seen it take on not just Teresa, but their entire family. He couldn't take the stand here today because he knew he would be too emotional. And you can't fault him for that. But what people want to know is, what does he want? Dirk submitted a victim impact statement that I know this court received by way of the PSI. Dirk, as a recognized victim under the law, told this court that in his opinion, an appropriate sentence is time served. I understand that some reaction may be, well, that's just because he's your husband. He's just saying that. For the last 2.5 years, they have not been able to talk about this case. You know, oftentimes we assume spouses can talk about anything they want because it's all protected, but this is a unique situation. In South Dakota, spousal privilege doesn't apply when you're a victim, and Dirk's a recognized victim. So from day one, they have not been able to talk about any of this. It's the biggest elephant in the room. The stress of all of it has been enormous. When I asked Dirk to explain more, he got quiet. And he told me it's the most isolating experience of his entire life. That when Teresa was arrested, they heard from no one. Those friends that they thought they would hear from. And he said very quickly, I know, what could you say? What is there to say? He goes, but nobody said anything. Nobody reached out. The toll this has taken on him is significant. It would be easy for him to be angry. It would be easy for him to throw up his hands and have walked away, and he hasn't. But Dirk, like his wife, cares most about his children and his grandchildren. And he is asking this court to give his voice the due consideration in not imposing any time against Teresa. As hard as this has been on the entire family, Teresa is the one who has obviously taken it the hardest. We have a woman who has worked hard her entire life, who for the last 2.5 years has been in her home by choice, but also by fear. Teresa doesn't go out in public. She's too afraid to be recognized, to be harassed, to potentially be hurt. Because what people think she did, what people think they know. It's been an incredible 2.5 years. And the thing is, even when we walk out of here today, even when this case is done, that doesn't just go away. Nobody's life goes back to normal, especially not hers. No matter what this court chooses to do, all of this will follow her for the rest of her life. Your Honor, the tragedy and the trauma of losing a son has been amplified for no reason. Theresa Bentis did not kill her child. She lost her son. She pled by way of Alfred as a way to maintain her innocence, but do whatever she could not to jeopardize being taken away from her family. If there is any silver lining in this case, it's that Andrew is now carried in the hearts of that entire family, just as he has been carried in her heart, as well as the heart of this community for the last 40 years. Your Honor, the standard penological goals of sentencing, of deterrence, rehabilitation, of punishment, none of those are satisfied by sending this woman to prison. The conviction for first-degree manslaughter standing alone is not enough. Justin made the comment a bit ago of how no institution could make this any worse on her than she's already punished herself. And I understand that sentiment, but Your Honor, I disagree. The way that this could be worse would be to put somebody in prison for something they did not do. Respectfully, Your Honor, and humbly, on behalf of Theresa Bentaas, as well as Dirk Bentis, Melissa Philmeyer, and Justin Bentis, recognized victims under Marcy's law, I am asking this court to impose a sentence of time served. Allow Teresa to walk out of this courtroom with her family. Allow them the opportunity to grieve the loss of their child. Give them the opportunity to heal as a group. And most importantly, Your Honor, give this family the opportunity to celebrate the life of a child so deeply loved. Enough is enough, Your Honor. We respectfully ask that you sentence Teresa to time served today. Thank you.
Thank you, Ms. Hansman. Mr. Sample?
Nothing, Your Honor.
All right. The court has heard all of the statements, the evidence that was presented, as well as the arguments. I have the information here as well. I'm going to recess for approximately an hour, and I'll return and render the sentence.
Judge, were you going to give her the opportunity to speak?
So I'd asked Ms. Hansman previously if Ms. Bentis was going to give an elocution statement, and I was told she was not, but okay. I will re-ask that question. Thank you, Mr. Sample. Does Ms. Bentis wish to give a statement?
No, Your Honor.
All right. Thank you, then. Anything further from the state?
The only thing, there's kind of a clerk issue that they pointed out a little earlier, that I don't think at the time of the plea we dismissed the other charges as part of that. So I guess we would do so on the record now.
All right. So noted. All right. Thank you. With that, folks, court's going to be in recess. The court is reviewing the new information that's been presented here this morning, and then I will blend that with the information I've already received in this case. Just for preface, before we come back, so that people understand how these matters come along. When this case was presented to this judge, this court, in the plea agreement the parties reached, this court said, I don't know if I will accept it. I said, I want the information because I want to make a knowledgeable and understanding determination, because just because people enter into plea agreements doesn't require the court to have to accept those. And as counsel knows here, and even law enforcement are here, this court has often rejected plea agreements because I don't believe they're appropriate under the circumstances. And so that was the case here. The council had presented it, and I went through everything, and I think it took about 60 to 90 days for this court to consider whether it would accept an Alford plea and whether to go forward. And so I made some comments about that during the change of plea proceeding, but I wanted everyone to understand that as well, that this part of the delay, if you want to talk about that, is upon the court, and the court considering how to proceed with this matter. And so with that, I'm going to go back to my chambers, and I'm going to deliberate over what the appropriate sentence in this matter should be. We'll be in recess until about noon. So with that,